Good morning, everyone on Zoom.
Lucius for his DUI.
I
I just confirmed with probation that he's done his victim impact panel and he's done his community service.
Receive assignment to be an interpreter.
Yes, ma'am.
For Mr. Lian, Mr. Lian, Lian is the last name.
Yes, ma'am. And I was just informed that he's an inmate and that the jail bus just got here. And so I'm aware that you're there. I asked them to bring him out as quick as they could. So once he gets in the courtroom, then we'll do his case, okay?
Okay, Your Honor.
And thank you so much. I really appreciate you being here. So again, Rachel, once.
Yes. Yes.
Mr. Garrett? And again, we don't have the inmates yet, so if your client's an inmate, we need to wait until they're here.
Custody, Your Honor. Your Honor, Chris Garrett on behalf of Alexander Maynard, 21 CF 354. Your Honor, this is a violation of probation, and I represent Mr. Maynard on the new law violation that triggered this VOP in Santa Rosa County. We are scheduled for a suppression hearing on April 29th. If we win the hearing, I would very much expect either an amended charge or perhaps for the case to go away. It's not quite dispositive, but it's pretty close. In speaking with the state, I believe the state doesn't want to make an offer until we see how this new case goes. We'd ask for a continuance to sometime in May, if possible. I don't know when the trial week would be if that case does go to trial, but it will be resolved within the next month or two.
Okay, so do you want to continue the VOP case and have it track with the new case?
Your Honor, the new case is in Santa Rosa County.
Gotcha. Okay, when are they going to have the trial in Santa Rosa?
The suppression hearing is scheduled for April 29th.
And you think that may be dispositive?
It might be, it probably is.
Okay.
So if we could have a court date sometime, maybe the middle of May, by that point I should either have a result from that or I should have a trial date set. My understanding is Mr. Maynard does want a trial if the state won't get rid of it.
Okay. So you want to set it without subpoenas on May 16th?
That sounds good, Your Honor,
Okay,
yes.
so May 16th at 9.
And I believe that's all I have, Your Honor.
Thank you, sir.
Have a good day, Your Honor.
You too. Mr. Rare?
Good morning, Your Honor.
Good morning, sir.
Judge, I've got two on the docket this morning. The first I'd like to call is Christian Everly. Mr. Everly is present with me today. And for the record, David Rare, 19 CF 905. Your Honor, we're before the court for a motion for early termination. We've been before the court before. Previously, the court determined that there was not enough passage of time on his probation period and denied it at the time, but without prejudice to come back before the court at a later date. We're now at a point where he's about 4/5 through his supervision period. It was 2 years community control, followed by 3 years probation from his original sentence. To this point, Judge, my understanding is he's completed all his terms and requirements. He's paid his court costs. He's paid his cost of supervision. He's been, my understanding, no speeding tickets, no really nothing since we were last before the court at all. And there is some brief testimony I'd like to elicit from him if I could.
Yes, sir. Mr. Everly, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand up.
And sir, just real quick for the record, what is your full name?
Everly?
And Mr. Everly, I have a few questions for you. Where do you currently work at?
Larry Bachelor Mechanical.
And speak a little bit slower and louder so the microphone can pick you up better.
Larry Bachelor Mechanical.
And generally at the mechanical, what do you do? What's your role there?
Sheet metal mechanic for $1 million company.
All right. And tell us a little about the company, what they do, what kind of work you do.
Install HVAC.
All right. Is there a particular title or role that you have at the company?
Foreman.
Foreman. In the role of foreman, what responsibilities have you been given with the company?
I've given the opportunities to watch over 5 guys for their safety and for my responsibility to get the job done in a correct manner way.
All right. Now, in that role, so it's a supervisory role? It's a supervisory role?
Yes, sir.
And then how long have you been entrusted with that supervisory role with that company?
4 years now.
All right, and that's been the period of while you've been on supervision?
Yes, sir.
All right, so at this point, what career goals or desires do you have to pursue with that company or otherwise?
I want to, well, probation is holding me back to make more money in my career. I do want to relieve myself for the probation so I could earn more
Right, and
trust.
Mr. Everett, I know you're nervous at public speaking, so we're working through this. As far as probation having an impact on your earning ability, what specifically is that? What is the restriction that's hurting your earning ability?
I can't leave till 6 or yeah, for early.
Okay, so is that an hourly restriction that keeps
An
you
hour
from earning
early.
more?
Yes, yes.
All right, if the court deemed fit to grant an early termination of supervision, which I think would be about a year early, what benefits would that provide to you? What can you do otherwise in your career?
I want to help. I want to help my family. My grandma needs. She needs help, and I want to. Oh my God, I'm sorry. I want to continue my career with this company, and yeah.
Sure. And then, final question on that, just to kind of get a little more understanding. With the company, is there a greater role you can play without the restrictions of probation, like hours? Is there a different salary you could achieve, a different level of employment you could achieve? What would that be?
Yes, I can. Probation is man, I can't. I'm sorry.
That's okay, just
That's okay. You can collect yourself,
relax.
it's fine.
You're just talking to me, okay?
Right.
I'm sorry. Can you repeat that question?
Sure. If the restrictions on your work hours and things that are impacting you with probation were to be lifted by the court, what impacts could that have on your future earning ability? Would that impact it in a positive way or not? Would you have more responsibilities or more work opportunities?
Yes, I'll have more responsibilities and opportunities.
And then it's generally, what might those opportunities be? What would you be afforded? What would you be more able to do in that situation? Whether it be work travel or...
Yes, more traveling within the company. I get, yeah, just more travel and more, yeah.
I know it's kind of hard to be speaking into a microphone like that, I understand. As far as independent of probation, completely separate from probation, you do have a sex offender registry requirement you have to abide by, correct?
Yes.
And have you obviously complied with
Yes.
that?
Yes.
So you sign that paperwork several times a year?
Yes.
And you've never had any issues with a failure to register or anything
No.
like that?
No.
And you understand, even if the court granted an early termination supervision, that requirement remains, that does not change, you still have to abide by all those conditions.
Yes.
Thus far, have you been able to comply with that, even with your work requirements, work travel requirements?
Yes.
So that would not change whether you're on probation or not, that would still maintain the same way?
It will change if, yeah, it will change.
As far as work, but your registration requirements, you understand that will not change?
No. Yes, I know, understand that.
Correct. All right, those are my questions, just kind of explain it and stuff like that.
Okay, to the state, any questions for Mr. Eberly?
No, Judge.
Okay. Is there any other evidence?
No other evidence, Your Honor, just maybe some brief argument, or depending on the state has any argument themselves.
To the state, do you have any evidence you wish to present?
No, Your Honor, just argument.
Okay, please, Mr. Rick.
Something that the state may address, and I'll just go ahead and address it first. The only violation allegation that has occurred since he was originally sentenced in March of 2020 was a VOP within the first month. I believe March 6, 2020 was his original sentencing date by Judge Stone. Later that month, I want to say between the 20th and 23rd, he had his initial formal full-on, here's my initial meeting with probation, go through all the conditions and everything. The basis for the first and only VOP was that he showed up probation and he had his phone with him, and it was a smartphone. So at the time, no internet access device until you go through the sex offender treatment counseling. They approve you for internet access, and you have full access restored through their conditions. He did not understand that at the time. The VOP, obviously probation was not revoked, was not sentenced to anything long term. It was a 60 days, $150, reinstate the original terms and conditions. Don't make that mistake again. He's been in full compliance since. There have been no new arrests. Like I said, no even criminal, speeding citations he's had since. He's been able to maintain employment. I told him earlier I was actually pretty impressed with him and what he's able to do as far as his career, maintain that. He placed in place of trust in a supervisory capacity with his company. It's a multi-million-dollar company and has several employees placed under him and be able to maintain that level of trust despite the adversity of the probation and conditions he's got court-ordered upon him. With what he's been able to achieve these last several years between control and probation, he's at about the 4/5 point, and there are some benefits to him were he to be granted an early release from probation by about a year early for his earning potential and his expanded roles within the company. We would ask the court to consider an early termination of probation at this time.
Thank you. To the state?
Judge, we're objecting to early termination at this time. As Mr. Rear mentioned, Mr. Eberly pled to the court to soliciting a minor for sexual conduct and traveling to meet a minor. The court, in a plea to the bench in March of 2020, granted him a reverse split sentence. First 2 years on CC, followed by 3 years of regular probation, with the 10-year DOC sentence as a reverse split hanging over his head. So he received a very significant break from the court up front with a reverse split. And as Mr. Rear mentioned, he has not been a model probationer. He did receive that VOP for having a smartphone. According to the affidavit, probation went to his home, saw the smartphone in plain view, and he denied being on the internet since being placed on probation to the officer. When the officer told him to pull up recent history and saw recent activity, he then admitted to being on Google and Craigslist, etc. He pled to 60 days in the Okaloosa County Jail and was reinstated on that in June of 2020. Given that he had the VOP, he received a significant break up front with a reverse split sentence, and that he's not scheduled to terminate for another year, as well as the risk to the community, and that this being an underlying sex offense, we'd ask the court to deny defense's motion for early termination at this time.
Mr. Eberly, as I was doing my homework, getting ready for this, I looked at really, and I was curious to see if the state was going to bring it up, which they didn't at all, which really is interesting. So to me, without them flagging it to the court, doesn't necessarily mean that it means a lot to them. But as I was looking at, and maybe it's implied in the argument from the state of don't terminate it, but I was looking at, if there's a sentence that says you'll be on probation, someone will be on probation, they'll pay an amount of money, they'll do this or that, and they've done everything they're supposed to do, then a lot of the things that they're required to do during that probation have been completed. As I was looking at the sentence for you, the things that continue and that you're obligated to do that first off, I don't put that much of an argument. I think Mr. Rare did a really good job of arguing the initial violation of probation. So I don't put a lot of credence in that violation. It makes sense that was trying to understand what this new world was that we were putting you in. But then I look at what your sentence was, and parens 11 of the sentence says random testing for alcohol and controlled substances. I don't see where in the arrest report where alcohol and those things was involved, so I don't say, well, that's something that really needs to stay for Mr. Eberly for the next year. Then I look at mandatory curfew. I assume that you've completed the sex offender treatment program, correct?
Yes.
Okay. No contact with victim would be another thing that is ongoing that would go for the next year. prohibiting contact with children. So you would be able to do those things. You have to register, but you would be able to have contact with the victim, contact with children. Presumably, you could work for pay as a volunteer at a place where there are children. I assume that you finished the sex offender treatment program.
Yes, sir.
Under probation, you're subject to warrantless searches, which I think that's probably in every probation. Annual polygraph examinations, that's something that the court wouldn't have, or probation wouldn't have the ability to do, which the court would be ending today. Maintain a driving log. This one's got electronic monitoring. Is Mr. Eberly, is he wearing a GPS monitor? Okay, so that would be something else that would terminate. So again, as I was doing my homework, I thought, what is the court really stopping that maybe should remain in place going forward? And those are the things that I look at, is contact with the victim, contact with children, going places where children may be, regularly congregate. The annual polygraph, not as much emphasis on that. Maintain a driving log and a GPS monitor. Because of what you admitted to, or at least what the court found you guilty of in the beginning as far as the original crimes, I do have concerns about terminating those early. So respectfully, your motion for early termination of probation is denied. Thank you, sir. Thank you, Mr. Rear. And Mr. Rear, we'll wait on your second case until we do the Chinese case.
translator.
Okay. Yes, sir. Thank you. Okay, first off, Madam Clerk, if you'll swear in the interpreter.
Yes.
你好，
She's on Zoom.
你好，
Yes, ma'am. There you can speak
你
right
好，我姓徐，我叫 Linda，来就帮你做翻译的。
OK， 好，谢谢。Thank you。
Yes, sir.
请法官评判，请法官评判我知道错了。
Okay, please, Madam Clerk.
Madam Interpreter, do you swear or affirm that you'll make an accurate, complete, and interpretation from the Mandarin language into the English language and vice versa relative to the cause now under consideration before the court?
Could you hear that? I'm sorry, your answer was?
No, I only have, I have three early termination.
Can you hear us? Okay, I'm gonna.
My name is Linda Campbell.
Okay, I'm going to stop your video camera, and maybe that'll give us some more bandwidth because you're freezing, okay? So I'm going to stop your video, but we'll still be able to hear you. Okay, there. So can you hear us now?
Yeah, much better because it was really breaking up.
Good. Well, I stopped your camera because of that. Did you hear what the clerk, she swore you in? Did you hear that oath?
Yes.
Okay, and
Now I can hear you better.
okay, do you agree to that?
Yes, yeah, I did.
Okay, thank you. So, you pronounce your name Yon Hu? How do you pronounce your last name?
Me
My last name is Giblin.
No,
H-I-B-B like a boy,
算了，别的那个。
L-N Giblin. H-I-B-B-E-L-N. My first name is Linda. L-I-N-D-A.
thank you, Ms. Giblin. Will you ask the defendant how he pronounces his last name?
His last name is Lien. The spelling is L-I-A-N. Pronounced as Lien. Mr. Lien.
Okay, good, so that's his last name is Lien.
Yes.
Okay.
His last name is Lien. His first name is Yen Hui.
Okay.
Y-E-N-H-U-I Yen Hui.
Okay, thank you. Mr. Lin, I can't imagine what it's like to not be able to fluently speak English in this environment.
法官说他没有办法想象，像你呢，因为没有办法了解英文，
So when the jail told me that you had been in the jail, I immediately set today's hearing.
你好像已经在这个监狱好像住了一阵子了，是吧？
是啊，因为我是18号进来的，我是上个月18号进来的。
I don't know what this. Your Honor, what case number
Now
is
the
this?
echoing sound is quite loud, so it's kind of hard for me to really clearly understand what Mr. Lin said.
Okay, if you'll hold on one second. To the state, it's 24 CF 662. Okay, so Mr. Lin, if you'll talk to the interpreter again, I don't know how to stop the echoing. Mr. Lin, if you'll ask Mr. Lin to tell you again what he last told you?
Yes, I will. And then I'm going to tell Mr. Lin to speak closer to the microphone. Just a moment. 林先生，
对啊，
你跟我说话的时候，能不能把你的嘴放靠近那个
OK， 好
麦克风，
好好好
我听不清楚你在讲什么。
好
你刚刚讲的再讲一遍给我。
因为我是 OK， 我是上个月18号进监狱的，所以说我今天我好紧张，所以说我会害怕。
Your Honor, I'm sorry, it's just echoing still very loud. I'm going to try to ask Mr. Lin to shorten his sentence so I can hear better. 林先生，你跟我讲，你每一句讲短一点哈，一小句一小句讲，因为那边的回音很大，所以我听不清楚。
好的。
第一句话是说什么？
第一句我是上个月18号被抓到，然后被关进监狱的。
好，等一下哈，18号是这个月的吗？
上个月3月份。
Okay, and back in March the 18th, I was arrested, and ever since I was locked in the jail. And I'm going to ask Ms. Lin what any additional sentence he was saying.
No.
I'm going to ask him to repeat again.
Okay.
Hold on a second.
Miss Giblin, Miss Giblin, Miss Giblin, Miss Giblin, yo, Miss Giblin.
被抓了是放在监狱里头，你下一句话是说什么？
Miss Giblin? Miss
然后我
Giblin?
下一句
Wait,
我
wait,
是
hold on, stop.
Yes.
Miss Giblin, I don't want him to tell me anything factually about his case. If you will just ask him if he wants me to appoint an attorney to represent him if he qualifies financially.
Got you. Hold on a second. 林先生，法官说呢，你要不要这个法院呢帮助你哈，帮你派一个政府的辩护律师给你哈？要是你没有钱的话，政府是可以帮你安排一个公家的辩护律师，你需要吗？
我需要，但是我是说我能不能让我早点放出去？今天放出去，因为我的孩子在中国没有学费，他要被赶出学校了，所以说我想请法官让我评判我今天可以放我出去吗？
Your Honor, the echoing sound very loud, and I cannot hear.
Okay,
hear what he's saying.
Miss Giblin, Miss Giblin, Miss Giblin, yo, Miss Giblin, Miss Giblin. Mi- Just-
Public defender. Hold on a second, let me
I was
ask
thinking
him
about this
again. 林先生，现在就回答我，你需不需要这个法院安排一个政府的辩护律师来帮你做辩护？
需要，
回答我好吗？
需要。
Wait, hold. Mr. Lin, if you'll move right here. Now, if you will talk into that. Yes, sir. If you'll tell Miss Giblin, if you'll talk. Miss Giblin, can you hear him better now if you'll speak?
Okay, let me ask him again.
Please.
Hold on a second, Your Honor. 那林先生，你刚刚问你的需
how much money did you average making per month before you were in jail?
你一个月做工作大概一个月赚多少钱？
我一个月大概赚3500。
You're not going to ask me to repeat again. I want to make sure what I hear is correct. 再讲一次。
3500块钱。
I make about $3,500 a month.
Okay. Mr. Lin, how long have you been in jail?
林先生，你被关在监狱关了几天了呀？
关有24天了，23天24天这样子。
I have been in jail 23 to 24 days. I'm not sure exactly, but it's about 23 to 24 days.
Okay. Mr. Lin, why haven't you hired a private attorney yourself?
那法官想知道这么多天了，你怎么没有自己想办法请一个律师呢？
因为我在里面，我语言不通，所以我讲不来话，所以说我就必须被关了。然后我今天还听到说今天上法庭。
The reason why I'm in there in the jail,
No, wait, hold on, Miss Giblin. I don't want Mr. Lin to tell me about why he's in jail or any of those things. I want to get him an attorney. I am here with the state, and if he says anything factually about his case, it can be used against him. So I don't want to hear anything about his case, okay? I just want to know why, financially, why didn't he hire a private attorney?
Got it. 法官说呢，不要告诉他你为什么被抓起来关，只是想问你为什么到现在关了20几天还没有自己去想办法请个律师？那很简单的回答一下为什么？
因为我联系不到外面家里人，所以请不到律师了。
Because I don't know how to do it.
Okay. To the public defender, Mr. Lin, I do appoint the public defender to represent you. I don't know how to get you assistance without doing that.
And Judge, his
So wait,
financial
if you'll
status-
let the interpreter, if she'll interpret that.
法官现在告诉你呢，法官呢要派一个呢，政府的公家的辩护律师给你，到时候律师会跟你详谈。Go ahead.
So the gentleman standing up is Mr. McKinney. He is your attorney.
现在呢有一个
你may
政府
wanna
他
move
的
over
律
here.
师就站在那个台前的，就是派给你的这个辩护律师。Go ahead.
Mr. McKinney, you may want to move closer to that mic too, or you'll be echoing. Okay.
Jason McKinney, for the record. And this is charged with the name Liam and last name Yan Lai. So that's why I provided my contact information, given the way that it is charged.
Your Honor, if I need to translate or interpret,
Yes, please.
I cannot really hear. The echoing sound is very loud.
Is this any better if I speak directly into the microphone? Is it any better if I speak directly at the TV?
Oh, yes. Now I can hear you clearly. Yes,
If
go
you want to
ahead.
move over there.
My name is Jason McKinney.
Okay,
If you can interpret that.
sure. 林先生，这个律师是公家的辩护律师，他的名字叫 Jason McKinney。Go ahead.
I am the attorney that the court has just appointed to your case.
这个先生叫 Jason McKinney 呢，就是法官呢刚刚判定的，要帮助你来做辩护的。Go ahead.
this charge is the first name Lian, last name Yan Hao. Is that
Incorrect. The first name is Yang Hui. The last name is Lian. So it's Mr. Lian. Go ahead.
and this is case number 24 CF 662.
你的案件号码呢是2024 CF 0662。Go ahead.
The state has filed 2 charges.
那政府呢要起诉你有2项。Go ahead.
Count 1 is domestic battery by strangulation, a felony.
OK， hold on。林先生有2项呢，第一项呢，你有那个家暴的行为，你还呢好像要这个掐了这个受害人的脖子，那这个呢控诉呢是重罪的控诉。Go ahead。
Count 2 is a domestic violence battery. And this
第2项告你的呢，就说呢也是家暴，然后你用了你的暴力的行为好像伤害了这个受害者。Go ahead。
For today's purposes, we're going to enter a plea of not guilty.
那今天呢，当然你要选项，你今天是要认罪呢，还是说你没罪呢，还是不抗？那你的辩护是说你要就是说选项呢是没有罪。Go ahead。
Right now, the pretrial conference that will be scheduled in this case is July 8th,
Okay, got it. At what time?
9 a.m.
9 a.m. Hold on. 那现在呢，因为呢，下一次呢，就说因为你要说你没罪的话，就要给你一个机会开庭。那在开庭之前呢，在7月8号早上9点钟呢，要见一个面，要确定下个礼拜要开庭啊。所以现在呢，在下一个要确定你要开庭的话，是在7月8号9点钟。Go ahead.
Because Mr. Lian is in jail, I would like to ask the court to advance this to May 13th, and I will endeavor to meet with Mr. Lian with an interpreter at the jail.
Gotcha. 那林先生，因为呢，你现在还被关在监狱，没有被保释出去，所以呢，你的律师呢，辩护律师呢，就要请求法官呢，不要等到7月8号，那希望请求他在5月13号，就来看看下一步要怎么做，然后到时候律师呢，会到监狱里去跟你好好的谈谈，然后呢，到时候也会派有个翻译的人员同行啊，Go ahead。
And that was a request to the court.
And that is granted. So, Mr. Lynn, I will see you back here no later than I'll see you back here no later than May 13th.
You want to clarify the May the 13th at 9 o'clock in the morning?
Yes, ma'am.
OK， got it。那林先生呢？现在法官也同意了，让你呢在就说在这之前呢，你的律师会跟你见面，会有一个翻译的人员陪同。那下一次到法院呢，就是5月13号的早上9点来确认是要开庭呢，要是开庭什么时候开庭。Go ahead。
那我是说我现在能不能放出去啊？或者是说我怎么保释能保释出去？保释多少钱？保释金啊？
I would like to know would I be granted to get funded out? If yes, how much would the fund be? Go ahead.
Okay. Mr. McKinney, do you have that figure, or do you want the clerk to tell you what it is?
I can pull it up, Judge, if you...
Or Madam Clerk can tell you. She's
20,000 cash professional for count 1, and 10,000 cash professional for count 2.
It would be a $30,000 cash for professional bond, which is typically 10% to a bond limit.
Got it. Hold on. 哎呦，林先生，保释金呢，政府的这个数字呢是3万块钱。那可是呢，你可以呢就跟这个就是去借这个钱哈。那基本上大概是10%啊。 那就是你可以去这些地方呢借这个钱，付个3000块钱，那就可以让你保释出去了。Go ahead。
那等一下，我是付监狱里面那个，只要把这个3000块钱交到监狱里面就可以去了，是不是
？I would like to know, so if I come up with that $3,000, I just gave it to the jail, then I can be out of jail. Is that correct? Go ahead.
No, you would need to contact a bondsman.
连先生，你必须呢要去找一个保释金的一个店面啦公司叫做 bondsman， 要去跟他们联络，他们要把这个3000块付到监狱的办公处或哪里。Go ahead。
等一下，我叫我外面的朋友来付这个钱，付到监狱里面去，可以吗？
Can I contact one of my friends to come up with the $3,000 and bring it to the jail? Would that work? Go ahead.
You would still need to use a bondsman. I would be happy to explain all this in person when I meet with you at the jail.
你还是必须要有一个 bondsman 那为什么要这样子呢？他跟你的那个辩护律师说，到时候他会到监狱呢，陪同一个发言人员去跟你解释，所以必须要有一个 bondsman 保释金的一个人员Go ahead。
这个我不懂你是什么意思？我意思是说，我意思是能不能
I don't understand
能不能简
what
单
are
一
you
点？
saying？
我是说能不能简单一点？就是说，我叫我朋友来监狱里面把这个钱付到监狱里面，然后我就可以放出去了。
I don't understand. Why can't I just have a friend bring $3,000 so I can be bonded out? Go ahead.
If you do not use a bondsman, then you would have to pay the full amount of the bond, which would be $30,000.
原因是呢，因为呢，这个bondsman就是保释金的这种人员他要拿出3万块放到这个交到这个法院让你保出来。虽然你只要拿3000块去跟这个保释金的这种机构去借这个钱，你要是再不了解，他到时候会再给你详细解释。Go ahead.
Mr. Leon, Mr. McKinney will come see you in the jail, and he'll have an interpreter that will be available so he represents you, nobody else in the world in this case but you, and he'll come see you in the jail and have an interpreter so you're not alone anymore.
Got it. 现在呢，就是你的律师，政府派给你的辩护律师呢，会安排一个时间，然后随同翻译人员到你的监狱，跟你好的解释下一个步骤应该怎么办。到时候你就可以问这个律师，这个翻译人员会帮助你的。Go ahead.
Okay. Thank you, sir. Thank you, Madam Interpreter.
You're welcome, Your Honor, and thank you so much for this opportunity to give you the service. Have a good day, everyone.
Thank you, ma'am. You too. To everyone, thank you for your patience for that. When I learned about this defendant, I just couldn't imagine being in jail in a foreign country where you can't understand anything. He didn't have an attorney, and so that was why we got him on the docket so quickly, so I appreciate y'all's patience. Mr. Rare, your next case.
Thank you, Your Honor. The other case I have on the docket this morning is Adam Barrows, 2015 CF 2395. He's present on Zoom. And Adam, if you could unmute yourself. Thank you. Your Honor, we're before the court for a motion for early termination and probation consideration. The original sentence for Mr. Barrows was 4 years at the Department of Corrections, which he's obviously served, to be followed by 6 years of probation. He's now passed the 2/3 mark. He's completed all conditions. He's appearing via Zoom because he resides in Georgia and has for some time. In supplement to the motion, we attached several letters of recommendation and achievements and some certifications that he's achieved since the court last modified to allow him internet access for work and educational purposes. We weren't planning to offer or elicit testimony today and rely on those documents that supplemented the motion.
Okay, and I did read through those letters, one of which I printed off that was from Kevin Rios, and I highlighted some things on that, but yes, sir. And I did read through the arrest report and then the motion.
Understood,
So,
Judge.
To the state, to the state argument?
I'm sorry, did you say argument?
Yes, ma'am.
Okay, we're objecting to early termination at this time. The defendant pled to traveling to meet a minor. As Mr. Rear mentioned, he was sentenced to 4 years in the Department of Corrections, followed by 6 years of sex offender probation. That did include provisions such as the GPS, no contact with minors, no internet or text-capable devices, or internet access except for work purposes. He's scheduled to terminate over a year and a half from now, I believe November of 2025. Probation would also object to early termination at this time, given that the sentence was for qualifying sex offense, and also that he has not completed his sex offender eval and treatment. Due to the nature of the charges, the outstanding conditions, including the sex offender eval and treatment that need to be completed, that he's still over a year and a half from his natural termination date, which was agreed to as part of a written plea agreement, the 6 years of sex offender probation, and that what to be gained by leaving him on for additional 18 months would be the GPS supervision, the no contact, or the no unsupervised contact with minors, limitations on internet access, and obviously the sex offender eval and treatment. We believe that probation should be continued until he reaches his natural termination date.
Mr. Rare, I think in your, well, you talked about his completed, a certain number of months. I don't know if you said in your motion that he's done everything, completed all the terms of his probation, but if he hasn't completed the sex offender evaluation and treatment, how is that a true statement?
So, Your Honor, I believe he has. And speaking with him about how Georgia handles these supervision issues versus Florida, Georgia has a kind of continuing thing where even if you complete the basic things, they still have you do follow-ups with them. It's not like Florida where you complete and you're done, and in the next 3 years you just don't have any treatment. There's kind of nothing there. They have you continue to do follow-up, and I can defer to him for some testimony to explain how Georgia does it differently than Florida. But obviously we provide the court, as you noted from Mr. Rios, what he's been doing counseling, the follow-up sessions and meeting with other folks and doing all that. I believe he has completed that requirement. Financial and otherwise, he's also completed those requirements. I think probation could probably verify the financials and all as well on that. And then, of course, we attached his certifications. The court afforded him the opportunity for educational access to the internet, and we provide proof that he's followed through with the court's ability to let him do that. And so I can call him for some brief testimony, but I believe he has met the requirements.
Okay. Even if he has, and, kind of foreshadowing with the last defendant as far as this is a unique, Mr. Barrios, this is, this type of crime in the probation is unique. All the different things that are involved in that. Certainly I'm concerned with the safety of the community. Before I rule, and I don't want to make it an all or nothing, is there something that the court could grant that would still provide the protections going forward that the court is going to require, but that would allow Mr. Barrios to do some additional things? Travel, anything that, instead of just an all or nothing, is there something that the court could lessen some of the obligations that would really help out Mr. Barrios?
Certainly financials are already done. As far as any curfew, I think because he's not a sex predator, it's a sex offender designation, the curfew I don't believe is mandatory. The court could order that there be no issue on that. As far as like a GPS monitor, if it's a sex predator, it would be a mandatory. The court would have to order that. If it's a sex offender status, at least for Florida's purposes, it's discretionary. Probation would recommend it if they feel it's appropriate, and then the court would enter an order approving that be put in place, but the court can order that. I do not feel the need, there is a need for a monitor, so the court can say that's not required. As far as follow-up, I think Georgia will say, even if you completed sex offender treatment through us and they recommend any follow-up or yearly evals while you're on probation, I think they're going to require that just by how their statutes work. I don't know if the court can change Georgia's, how they handle that. I think there may be something there for that. As far as compliance, something the state mentioned, they mentioned a plea, and pursuant to a plea, he agreed to 4 years DOC followed by 6 years probation, and he must be bound by that, implying the court cannot deviate from that. We cited the ENIA v. State in our motion, which specifically says that is not the case. Even under a plea agreement, the court retains the authority to modify or early terminate, if it so chooses,
I agree.
any probationary
I
sentence.
agree. The appellate cases say that the court can modify probation supervision. Yes, sir.
Correct. And I'll just add, in this case, there have been no alleged violations of probation, whether it be in Florida or under his supervision in Georgia. I think he's demonstrated, especially with the documentary evidence provided, his ability to comply with the law, conform with the law, rehabilitate himself through the sexual programs provided by the state of Georgia, where he's been supervised and monitored there, and that he does not pose a threat of continuing harm to the community. And similar to earlier, and same applies here, the designation status, whether he's on probation or not, would not change. Those requirements would still be in place regardless.
And so I was going to ask a question, but you answered it in your motion. I was curious how long Mr. Barrios has been out, and he's been out since November 21st of 2019. Because of that passage of time, the court grants your motion in part and denies it in part. The court grants it that Mr. Barrios does not need to wear a GPS monitor for the balance of his supervision, but the other terms of his supervision will remain.
Understood, Your Honor.
Mr. Barrios, I thank you so much for doing everything that's required. I just have concerns about the safety of the community because it means a big difference to the court, to this court, me, when, you know, the facts are that someone traveled to meet a minor. So that's the reason why I didn't terminate your supervision. Okay? So, thank you, sir. So, Mr. Rare, if you'll get me a proposed order.
I will, Judge. Thank you.
Thank
That's
you.
all I have about the excuse.
Yes, sir. Thank you. Ms. Graham. Good morning, ma'am.
Good morning, Your Honor. Tricia Graham on behalf of Jeremiah Lovejoy.
Hello, Mr. Lovejoy.
Your Honor, we're here today on defendant's request for a motion to reduce or modify his bond. Before we proceed, I do want to modify or amend my motion. I did indicate in number 4 he had no known prior failures to appear, and in further research he does have one in 2013, over 10 years ago, and the state did inform me he also has one in 2012. So that was not accurate in my motion. Mr. Lovejoy, as you know, is his bond right now is at $10,000, and for count 1, for possession of firearm, and count 2 for an aggravated assault is $150,000. He's been incarcerated for quite some time, and he does have a medical condition of diabetes. He is being treated in the jail for that. However, the quality of the insulin that he's receiving, he has been reacting to. You can tell he's lost weight, and he's been communicating with his mother about his condition and complaining about some numbness and so forth. I've asked that he continue to notify the nurse and everything in the jail, but that's just been something that's been affecting him throughout this time period and kind of fluctuating. Although it's managed, it does create a health issue, and I noticed in speaking with him, kind of that changes his demeanor as well. So that's just a medical concern that I wanted to address to the court, that I think one of the reasons why he really would like to have bond at this point is to get his medical situation up to speed, so he's feeling a lot better. And so we can be able to communicate better regarding his case as well. He's been a resident his whole life here in Okaloosa County, and his family doesn't have the means to pay for the bond as projected. They've been pulling together to work resources to get him out. We don't have a specific request, with obviously the discretion of the judge, but if you would consider keeping the count 1 at 10,000, but reducing the count 2 at least to the 15,000, so that would be something possible for him to make that bond in whatever conditions that the court deems appropriate under the circumstances given the charges. Right now, he does indicate that he does have work that could be ready for him, so he would be able to do that and start making some payments towards whatever is needed to reimburse his family. He, as indicated, his prior failure to appear, he hasn't been in trouble since 2014, the past, and there was some juvenile stuff before, so he does have a criminal history. But not since that over 10-year time frame. And we'd like to resolve this case and get him up to health and have more opportunity to meet in person. But the big thing is for him to be with his family and to get his health, and they cannot afford the bond as set. So we request that it be reduced in whatever manner the court deems appropriate. I understand the state is objecting to that, and just wanted to clarify.
Okay, thanks, Ms. Graham. To the state.
Yes, Your Honor, the state is respectfully objecting to this motion to reduce or modify the bond. First reason is because we feel as though the bonds that are set, namely the $10,000 on the possession of a firearm by a convicted felon and the $150 on the aggravated assault, we think they're extremely warranted in this case. The facts of this case is that the defendant actually pointed the firearm at the victim, loaded it, and fired a bullet towards the victim. I also want to bring to the court's attention that in this defendant's prior record, there are 2 prior failures to appear. The state does concede those were in 2013 and 2012. We also want to point out that in 2013, this defendant pled guilty to the threat to aggravated assault with a deadly weapon with intent to kill as well. And so it seems as though that was some time ago, but the defendant is still displaying this violence towards the community. Given that he isn't supposed to be in possession of a firearm to begin with, he's then in possession of a firearm and actually takes the step of firing a bullet. The state does have concerns for the community and for the victim, and so for this reason we would respectfully request that the bonds on count 1 and count 2 remain as they are in place at $10,000 on count 1 and $150,000 on count 2.
Thank you. Ms. Graham, find that?
Yes, Your Honor. We've not declined to get into the facts of the case. It are serious charges. It does indicate also in the police report that the alleged victim still approached the defendant even after that. So I'm not going to get into the facts of the firing. This case involved a situation where there was a video, which we don't have. And so there's a discrepancy as to the circumstances, which I'm not appropriate to get into at this time. But we are not denying the allegations of the seriousness of the charges that have been alleged. However, just to reduce the bond, right now, he hasn't been in trouble for that time period. He's got a support of the family network, and we like to address it that way so he can have that support. And given the time frame that has passed without being involved in any crimes, should get some, that should be evaluated as well.
I understand. Mr. Lovejoy, I did read through the addendum to probable cause. If it was just that, as far as the count 2 and not the count 1, it'd be a more difficult decision for the court. But because of your past and the past conviction and then the seriousness of the alleged crime this time, it's not a very difficult decision for the court. Respectfully, your motion to reduce or modify bond is denied. So when will I see Mr. Lovejoy next? Will it
We're
be May
scheduled for the-
13th?
May
Yes, Your
13th, Your Honor.
I'll see you then, Mr. Lovejoy.
Thank you, Your Honor. Thank you,
Thanks, Ms.
Stacey.
Graham. Okay, any other private counsel? Yes, sir, come on up.
Rick Albritton on behalf of Kendare Hogan.
Yes, sir. Hello, Mr. Albert.
Good morning, sir.
Morning, sir. Hello, Mr. Hogan.
And Judge, we're here this morning on a motion to early terminate Mr. Hogan's probation.
Yes, sir.
As set forth in the motion, Mr. Hogan's has completed all the special conditions of his probation. He's satisfied all of his monetary requirements, and he's current on his cost of supervision. As a preliminary matter, I sent the referral and completion to the state earlier. However,
They has completed everything.
may I approach?
Yes, sir. Thank you, sir.
Evaluation and all.
Good. Thank you.
As the court can see, it was a 3-year program that he completed, and he was cooperative and successfully completed it all. We've got several members of Mr. Hogan's family here today, and if it's acceptable to the court, I'd like to ask
Yes,
some of
sir.
them to come up.
Sure.
I'd like to call Elena Bird.
Okay. Ms. Bird, if you'll come to the witness stand.
All right, Ms. Bird, would you introduce yourself to the court, please?
I think they can file that. Hang on.
Introduce yourself to the court.
I am Helena Bird. I am his aunt
And have you known him all of his life?
all of his life.
All righty. What can you tell us about Mr. Hogan's before this period of probation versus Mr. Hogan's after this period of probation?
Well, before, he was young, immature. In the present day now, he's lost both his parents. I'm his overseer. I'm a retired correction officer. My husband and I both out of Bay County Sheriff's Department, and a retired gang intelligence officer. And he has more supervision with me versus being on probation. He's paid everything. I made him pay everything, made him go to class. He is, when I say did 110 turnaround, he has. He can't move without Auntie knowing it. And that's mandatory. And he takes care of my mother. She's 76 years old. And it was very hard for him when my brother had a stroke 6 months ago. I wasn't able to go due to my job as a bondsman. He couldn't take my mother down there to see about her son because of probation. So I want him to have a life, because he hasn't had one. He's had a real rough life. And with both his parents, because my brother just passed away 2 years ago, he's been through a lot. And he's excelled, got a good job, he's a plumber. Didn't think he would do that, be playing plumber stuff, but he's doing it. He's going to work every day, don't miss work. He's at home, he's playing semi-football, which he's pretty good at the center. And we go support him, and I'm his backbone. Me, my mom, and my husband. And my husband's the one in the black standing there, the little guy. So.
Now, Mr. Hogan's here is, he's a big fellow too.
Yeah. But
Would
to
you
me-
say that when he got onto probation initially, that his maturity level wasn't quite as up
Right.
with his physical size?
Yes, correct.
How would you say that he has matured in the time that he's been on probation?
Well, now you don't have to lead him into, hey, Kendare, you need to go take care of this. Or like now, he's wanting to buy a car. So what he does, when he gets paid, he sends me his money to help save for his car. You'd have never got that 6 years ago. He'd just been like, he's just very responsible with taking care of the things he needs to take care of. He went to his classes, he paid his probation, he paid more on his probation to get it taken care of, because when we first started it, it was like $4,000 when my brother passed. And that wasn't sticking very well with Auntie. And he took care of it. I told him what he needed to do, and he done it. I mean, he's just I don't really feel like he needs to be on probation anymore.
What about taking care of your mother? What sort of tasks does he do?
Well, when I come to taking care of her, that's her fishing partner. to be able to go wherever she need to go, and she's not in the house by herself. He's there. He's taking care of her. He's taking the trash out, helping her clean up, and that's like her having her son back. Because when she,
Would termination of his probation assist in that for him?
yes, because then he's able to drive her to different places that she has to go on her doctor's appointments and different stuff like that. He's able to go with her. I don't have to stop doing what I'm doing. I know he's there with her. I don't worry about him if he's there. But right now, he can't. So it's
And
like,
are you aware of his day-to-day, what he does and all that?
oh, yeah.
What does it consist of?
Working. He has to be to work by, she leaves the house, I think 5:45. He's there by 7. He gets off about 3:30. If they're not on the Fish Creek, he's at home. There's nowhere for him to go. And I'm not a person who trusts people with my vehicles, but if I need him to do something, I'll send him off with my car. Hey, I need you to go to the store, get auntie such and such. She'll do it as well. He does everything we ask him to do. He doesn't teeter from it.
As he stands here today, do you have any concerns that he would return to any sort of behavior like what landed him here to begin with?
No, I don't have any concerns of that.
Why is that?
Because him and I, we have some long talks. He don't even have that mental state of what happened in the past. That's a grown man now. That was a child to me that got that probation charge and that charge. That's a grown man.
Can you think of any reason why he was less mature then?
Yeah, he was, I love my brother, but my brother had issues as well, mentally. And I think a lot of that played in a part of how he was brought up with his father. You know, it's one of those things where he wasn't tough enough on him and didn't keep his eye on him because of his maturity.
What about teaching him to do the things that we have required to do as grown-ups in the day? I mean, bank accounts, paying your bills, all that stuff.
Well, he has his cash out card with his bank account, and that's how he keeps up with everything.
I mean, before, when his...
Before he didn't have none of that.
And had he been taught any of those things?
Oh, no.
And was it just mainly because his father liked to do those himself?
His dad liked to be in control.
And so, in the intervening time since the passing of your brother and his father, have you made an effort to teach him those things?
Yes, almost every week.
And so, would you say you've been successful?
Yes, definitely. We're not gonna fail. That's what we're not gonna do.
Is there anything that you would like to tell the court about Ken Derrick that we haven't discussed today that you think is important?
No, not really. Just set him free. Let him be a man. Let him do what he's continuing to do, and I can promise you won't see him again.
Nothing further for the witness, Judge.
From the state, questions for Ms. Byrd?
No, Your Honor.
Okay, thank you, ma'am. You can step down. Any other evidence?
You're going to have just a moment, Your Honor.
Yes, sir.
I'd like to call my client, Mr. Hogan.
Okay, Mr. Hogan's, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Introduce yourself.
My name is Kendarick Hogans.
All right, sir. And back in 2020, you were placed on probation by this court, is that right?
Yes, sir.
All right. And 5 years, long time?
Yes, sir.
And has it been difficult?
Yes, sir.
Can you describe some of the difficulties for the court?
I can't take my grandma to like out of town or anything like that without being having a travel permit and stuff like that. Can't travel to play football or nothing like that. And when like say like when I gotta go to see my PO officer or whatever, I gotta call out of work and don't even go to work or something like that.
Was it challenging for you to complete the requirements of probation, like the sex offender counseling and all that? And would you say that you learned a lot when you were doing it?
I learned a lot.
And do you believe that participating in that program and what you've learned has led you to a greater understanding of what you did wrong and why it was wrong and how not to do it anymore?
Yes, sir. I'll never do it again.
And is it your desire for the court to today terminate your probation and allow you to get on with your life?
Yes, sir.
Nothing further, Judge.
Okay, thank you. Any questions from the state?
No, Your Honor.
Okay, thank you. Yes, sir, argument?
Yes, sir. Mr. Hogan's was placed on probation in March of 2020. He's done more than 4 years of his sentence, which would account to more than 80%. We let people out of prison at 80%. He wasn't convicted of any charges. The court withheld adjudication. And I have spoken with the state, and I understand their position is that he got a break by getting the plea that he got. I would, however, urge the court to examine, obviously, the context of this. If the state had deemed him to be dangerous, they would have insisted on an adjudication, probably a designation, and maybe even prison time. They allowed him to plead to a lesser charge, a felony battery, and he has, I would hope, satisfied the concerns of any naysayers by his performance on probation, his completion of everything, the support system he has in place, and his general willingness to abide by everything that the court has asked him to do. I know that in the 80s or whatever, the philosophy behind sentences switched from rehabilitation to punitive measures and all of that, but we also still ask them to become productive members of society and to get out there and live lives that are worthy and garner, if not the admiration of our fellows, at least the respect. And I believe that he has accomplished those things and is poised now to become what we've asked him to be.
Thank you, sir. To the state?
Judge, as Mr. Albritton said, he was allowed to plea in March of 2020 to felony battery with the withholding of 5 years of probation. Terms included no contact with the victim or victim's family, sex offender eval and treatment, no unsupervised contact with minors. My office did speak with his probation officer, Johnson, and she confirmed that he completed his requirements. However, she is not in support of early termination at this time. He's scheduled to terminate March of 2025, so he does have almost a year of supervision left and did receive the benefit of the bargain by receiving the withhold and not being designated as a sex offender with the felony battery plea. Brief underlying facts, according to the police report, involve law enforcement finding a 21-year-old defendant with a 15-year-old victim, and post-Miranda, he did admit to having oral sex with her and digitally penetrating her. The 15-year-old victim said the defendant told her he was 17 at the time. However, of course, he was 21. I know there are references to how old he was and that he was a boy at the time, certainly by testimony today, but he was 21 years old when this happened. So there were no violations while on probation, but we are objecting to early termination in this case, given he's still a year away from the natural termination date. We do believe that he should do the full term of probation as agreed in the written plea agreement, and terms to be gained would be the prohibition on contact with the live victim and her family, and the no unsupervised contact with minors hanging over his head.
Thank you. Mr. Hogan's, I did my homework, read through the arrest report, the affidavit, the attachment to that. Highlighted different things in there. I have to smile because Auntie, as she calls herself, she talks about mandatory. If the court grants your motion, and right now you're not ordered to follow what she wants you to do. It isn't mandatory from the court's perspective. But certainly, it sounds like from your auntie's background and listening to her testify that she has a lot of wisdom and that you probably would do well by listening to her advice. It will be up to you whether you decide to follow that at all. When she said, "I promise you, you will not see him again," she can't promise me that. I mean, she can say it. But you're the only one that can keep yourself out of this court.
Yes, sir.
Watching your testimony, watching your face, first off, you had a little smile that cracked when you talked about football, and then very sincere expression on your face when you were asked, did you learn a lot through counseling? And you said, I learned a lot. And there was a lot of conviction in the way that you acted and what you said. So I encourage you to keep your support system. Don't lose that. It'll be up to you to decide whether you want to follow that advice or not. You're a grown man. Your motion for early termination is granted.
Thank you.
Thank you, sir. Good luck to you.
Thank you.
Thank you,
Thank you,
Mr.
Your
Albert. Okay, we have Ms. Tidwell on Zoom.
Judge, that's Mr. McKinney's case.
Mr. McKinney's out of the courtroom. When he comes back, then Ms. Tidwell will take your case to the folks in the gallery. I don't know if we have any pro ses. Okay. Daniel Peterson. Okay, good. Okay.
Mr. McKinney is here. It
Okay.
shouldn't take
Why don't we
just a
do Mr.
second.
McKinney first? Mr. McKinney, we have Ms. Tidwell on Zoom.
Yes, Judge. Ms. Tidwell is present on Zoom. She's here in 19 CF 2519 and 19 CF 2521. She does reside in Alabama. This is a felony violation of probation. And part of the basis for the violation of probation is a new law offense in Alabama, which Ms. Tidwell is currently entered a plea of not guilty and is currently going through up there. It's based off of that I believe it's the mutual request from the defense and the state to set this off a much longer period of time than we normally would to see the result of that, because that would materially change what we talk about in the courtroom here in Florida. So I'm going to ask for a continuance, and I'm going to ask the court to set an August 15th court date in the morning at 9 a.m. for the violations of probation without subpoenas.
Any objection from the state?
No, Judge, that's the state's agreement.
Okay. Ms. Tidwell, do you agree to that continuance?
Yes, sir.
Okay, I'll see you back here on August 15th at 9 o'clock, okay?
Ms. Tidwell, if that case resolves in Alabama ahead of that court date, then certainly we can schedule an earlier court date in front of Judge Brown. Everything will be kind of dependent upon you keeping in good contact with me and making sure that we're up to date on everything that happens in Alabama.
So, Ms. Tidwell, your homework is stay in touch with Mr. McKinney, okay? Thank you, ma'am.
Thank you, Judge.
Judge, that's all I have before Your Honor, if I may be excused.
Yes, ma'am, thank you. Okay, yes, ma'am. Thank you. Hello, Mr. Mary. Doing well, how are you?
Doing all right.
Mr. Berry, so this is 21 CF 2248. Does the state have an offer for Mr. Berry, or do I need to appoint an attorney?
Hold on, Your Honor, I'm trying to find it.
Number 8 on my docket. Berry.
Your Honor, at this time, there's going to be a DOC offer.
Okay. Mr. Berry, do you want me to appoint the public defender if you qualify financially?
I thought that Mr. Shield, Lawrence Shield was my attorney.
Okay, I don't have, did you hire an attorney?
Yes, sir.
Okay. He hasn't filed a notice of appearance that I'm aware of.
Okay, I thought he was the one that filed to get me in here today.
No, sir.
Okay.
No, we still don't have an attorney listed for you.
Okay.
You know, it's up to you what you want to do. If you qualify financially, I can appoint the public defender. If you want to talk to Mr. Shilley and, you know, get him to file something and set it for a hearing, I'm going to set it for some kind of hearing because I don't want you to totally fall off the radar that
Okay.
you're sitting in jail, and, you know, I want to keep track of your case.
All right.
But it's up to you. Do you?
Well, until I can talk to Mr. Shield, I would like to be appointed a lawyer.
Okay. How much money do you make per month?
Well, I've been in prison I've been incarcerated for 2 years.
Okay. I do appoint the public defender to represent you. Mr. Kleins is approaching on your right.
Hey, how's it going?
Your Honor, we will enter a denial today, ask that this be set on the first available date in May. And I was just informing Mr. Berry, if the notice of appearance is filed, I'll obviously step back, but until then, I'll move forward as quick as I can.
Good. So, Mr. Berry, I'll see you no later than May 16th.
Okay.
If something comes up before that and a motion is filed or the state offers you something that you want to accept, then Mr. Kleins can set a hearing before then.
Yes, sir.
Thank you, sir. I'll come talk to you. Thank you. This is 23 CF 731. Hello, Mr. Peterson. Good morning. Mr. Peterson, do you wish for me to appoint the public defender if you qualify financially?
Please.
How much money do you make per month?
Nothing.
How long have you been unemployed?
Technically, I was employed for 2 days prior to my arrest, so I'd have no idea what,
Okay,
before
so
that had
other
been
than
years.
those 2 days, when
It's
was the
been-
last?
I couldn't tell you, it's been more than a year.
Okay. I do appoint the public defender to represent you. Mr. Koch is approaching on your right.
Good morning, Judge.
You cut your hair.
Yes. Your Honor, we'll be entering a denial, and if we can have this set for the next BOP.
Well, do you want it next week, or do you want it a month from now?
Could we get it for next week?
Yes, sir. Do you want it on the 15th or the 18th?
If we could do the 18th, Judge.
Okay. So, Mr. Peterson, I'll see you on next week, April 18th at 9 o'clock, okay?
We'll talk about it. Thank you, Judge.
Thank you. Thanks, Mr. Peters. Tamika Tassin? Good. Hello, Ms. Tassin. 19 CF 188. Does the state have an offer for Ms. Tassin?
Hold on, Your Honor.
Ms. Tassin, is the state's looking for that? I don't want to waste a lot of your time and money if the state wants to offer you something, a pretrial diversion or something that you may want to accept
Yes, sir.
without needing an attorney. Let's hear it.
Yes, sir.
If not, then I'll ask you about an attorney.
Can I speak real quick?
Why don't we wait and see what they say? Know that if you say anything factually about your case, it can be used against you. So that's why I want to talk to you about an attorney before you say anything.
This isn't my case, Your Honor. I'm covering for ASA Snell, so at this time, I'm not comfortable with making an offer and it not being appropriate. So I would ask that we put it to 4/18 to allow him some time, because it seems like one where we should be able to have a resolution soon. I just don't want to say that, I don't want to make an offer and that be the wrong one.
Understand. So, Ms. Tassin, what the state's asking is just continue today and maybe you come back a week from today. And hopefully, the assistant state attorney that's handling your case will be able to offer you something, hopefully that's palatable to you, something that you may want to accept without an attorney. But if you say, nope, Judge, I don't want to do that, I want an attorney, I can ask you if you qualify. If you do, it's a $50 application fee and a $100 actual fee, so it's $150. But it's up to you what you want to do.
Judge, may I ask her a question?
Sure.
As a friend of the court? Judge, if the court is moving this to another court date, it looks like this is financial only, and I believe that she may be trying to make payments on that if we set it for a May date.
Okay, so to the state.
We would agree with that, because if that's what I was saying, it does appear to be just financial, so if she comes in May and it's paid off, then we'll dismiss. So I think that would be a better
Good.
avenue to
Thank
take.
you, Mr. McKinney. Ms. Tassin, how far out, you want me to set it for the end of May, May 23rd?
Yes, that would be.
Okay, so I'll see you back here on May 23rd at 9 o'clock.
Yes, sir.
Thank you, ma'am. Mr. Kleins, or
just have one in the gallery room, Dana Lucius. Mr. Lucius is present and approaching. I talked with Mr. Gomez. I believe the state has an announcement.
Yes, Your Honor. And speaking with probation, I believe just about everything is done with the exception of the cost. So at this time, we would revoke and terminate and then convert cost to a civil lien. We would dismiss the VOP, revoke and terminate, and convert cost to a civil lien, Your Honor.
Okay. Mr. Lucius, I don't see any downside to that, so.
The one thing, I don't mean to cut Your Honor off. The one thing, I know he wants to try to make these court cost payments. It's about in the neighborhood of $2,200. So I think Mr. Lucius was intending to ask the court to give him 9 months to try to pay those before it affects his license.
Good. So, Mr. Lucius, your supervision is terminated today, so you're off probation. And if you fail to pay the outstanding financials within 9 months from today, then they will go to a civil lien or judgment.
Okay.
Thank you, sir.
All right, man. Good luck, okay?
And the VOP is dismissed. Yes, ma'am. Thank you. Okay, other folks in the gallery? Okay. Other folks in the gallery, Mr. Cott or Mr. McKinney, either one.
Judge, could we call Ms. Joan Rudd, who's present?
Mr. Rudd?
Rudd, R-U-D-D, it's
Yes, sir.
23 CF 1987.
Yes, sir.
Yes, Your Honor. Your Honor, I'm asking if we could set this on the 4/18th date, so I can speak with the state to possibly either reinstate or resolve.
Who is this, Your Honor? I'm sorry.
Ms. Rudd? It's number 17 on my docket. Hello, Ms. Rudd.
Hi, how are you?
Good morning. Good, how are you?
Your Honor, the offer that I have by Mr. Snell is to reinstate with the same terms and conditions modified to include a substance abuse evaluation, curfew 7 to 7, and would be amenable to working around her schedule, plus a urinalysis for 6 months. That would be the offer, and I don't anticipate that changing between now and the 18th.
Your Honor, my client would like, if we could still, excuse me, push this to that 4/18. She does want, plan on paying off some costs, and I'd like the opportunity to speak with Mr. Snell.
Okay. Ms. Rudd, then I'll see you back here a week from today. Think about what that offer is. You decide whether it's in your best interest or not to accept it, okay?
Yes, sir.
And I'll see you back here on April 18th at 9 o'clock.
Thank you.
Thank you, ma'am.
Your Honor, if I could pass up mine just for a brief moment and pass it to Mr.
Sure. Mr. McKinney.
Judge, I have Tyler Hale in the courtroom. Mr. Hale is approaching on 2 case numbers. Each are felony violations of probation, 21 CF 2340, 21 CF 3143. In speaking with Mr. Gomez this morning, I believe that the state's offer is going to include a Phoenix House component. Mr. Hale has not been evaluated by that program, so I'm going to seek a continuance so that we can do that. But we're also looking at other options as well as far as treatment. He is currently doing Pattison and doing well with that. So I do want to continue this until a May date. I think the first May date would be appropriate.
Okay. So, Mr. Hale, I'll see you back here on May 16th at 9 o'clock, okay?
Yes, sir.
Thank you,
Hey,
sir.
good job today with that interpreter.
Thank you, sir. Okay. No one else in the gallery that's a defendant?
What did you say?
Tina Snow.
Okay.
Sure. Alexander wasn't mental.
Okay, please.
She already got evaluated.
Ms. Roberts?
Now she's doing her weekly. She walks here every time, and she always should. Can we dismiss and put the costs?
No, she needs to finish the everything, and then we'll dismiss.
Okay, no, cool.
Ms. Roberts, let me find you on my docket.
Thank you. I was confused.
Okay, thank you.
Thank you very much.
Was she plea day or?
Yes.
Oh, okay.
And it's, okay, it's 18 on mine, but it's 24 CF 501. Ms. Roberts, do you intend to hire a private attorney?
Yes.
Okay. So what you've been given is the information. It's the formal charging document from the state, charging you with fleeing and attempting to elude and reckless driving. I will enter a denial for you. You need to hire your attorney, get them on board sooner than later so they can start working on your case.
Yes, sir.
What is the date that it shows on you? Okay, so May 13th?
May 13th.
Is when you'll need to be back
At
here.
9.
On the 9th? Yes, ma'am.
All right.
May 13th at 9 o'clock. Get that attorney on board where they can talk to the state, and start working your case.
Okay, yes, sir.
So I'll see you on May 13th.
Thank you so much.
Thank you, ma'am.
Have a good day.
Thanks for coming early.
Thank you.
Let's continue to, I apologize.
It's just the May 13th pretrial.
Thank you, Judge. And just for the record, Mr. Snell did have an offer for that case. However, with this being that charge, there is an automatic driver's license, so I think it benefits the defendant to make sure that she speaks with
Okay, Ms. Roberts,
the
come on
attorney.
back. Why don't you tell Ms. Roberts what it is where she
Okay.
can tell her attorney?
I was mainly wanting you to know that Mr. Snell had provided an offer. It wasn't just that we didn't have one, but this particular charge generally incorporates a driver's license suspension, so I think it would be in your best interest to make sure you speak with your attorney.
Right, but what are the other terms of the offer so Ms. Roberts can? tell her?
Right now, it's just an adjudication of guilt, 1 year probation, 1 year driver's license suspension. That's per statute, 50 hours of community service work, and the advanced driver improvement course.
Okay.
No, thank you.
So, but then you can just tell your attorney what he's starting with, okay?
Okay.
Thank
All
you,
right.
ma'am.
Thank you.
Yes, ma'am. Yes, ma'am.
Judge, if I could call Ms. Tina Stone, who's present and approaching.
Hello, Ms. Stone. Yes, sir.
Judge, last time we were in court, our client had the outstanding mental health eval, and she went to Bridgeway. Her second appointment is on the 19th of this month, and she expects to have weekly appointments over at Bridgeway after that, just to complete the evaluation and the treatment. If I can get another date at the end of May, because for her to complete all this treatment, but she's down the right path and keep her appointments.
Good. Okay. Ms. Stone, I'll see you back here on May 23rd at 9 o'clock. Keep going to your treatments, okay?
Yes, sir. Thank you.
Thank you, ma'am.
Let me write that down. 23rd.
Okay.
Hold on a second.
Which is fine, I can set it, but
Yeah, that's fine.
the last thing was a lot of confusion.
Okay. Thank you. Yes, sir.
It's the 23rd at 9 a.m. Okay. And Your Honor, I do have another client in the court, Joshua Smith. If I could have another moment to go over the plea form with him.
Sure. Okay, and Rachel, I think you've got the document.
It was fine.
We'll start with,
Scott. Filed a no process this morning on that. Yeah.
Thank you.
Did you say McBride is first?
No.
Oh. Okay. I'm so over this. Locked into my.
Your Honor, this is Ms. Burkhalter. Mr. Gomez informed me that this morning he filed a no cross of Ms. Burkhalter's case.
Good, excellent.
And I just want to make sure, no pros was correct, because to my knowledge, there was no information filed. Is that correct, Ms. Lepee? I just want to make sure I got you the right document, because the last time I did this, I had to go through a couple hoops to make sure that it got done. So I just wanted to make sure. I was just trying to get this case off our docket as quickly as possible.
Correct.
Okay.
Okay. So your case is dismissed. Okay.
The final, and it's
Yep.
removed
Yes.
separately
It is
from
done.
any record.
Well, no, hold on. I don't want to represent to her that it's removed from a record. She has to go through.
Hold on one. Okay,
That's
this,
regarding Chris Teddy Burkhalter, date of birth 2/4/1969, dismissed in full.
it's dismissed in full, but hold on, you said removed from the record.
Yeah, I just want you to know, like, you have to go through a separate process to completely remove it from your record. So like, if somebody were to go to your record, it would still say the charge and it would say dismissed, but to get it removed from your record, you have to go through a separate process.
Thank you. It was never an actual conviction, so I have to have a process that dismiss. So I leave today.
You should.
Yes, ma'am.
All
Thank
right.
you, ma'am.
Good luck.
Thank you.
It's like a 2019 case that she just got picked up on.
Your Honor, this is Ms.
Ms.
McBride.
McBride.
She is on today's docket in 23 CF 262. This is a violation of probation. We will deny the violation. She is on next Thursday's arraignment docket in 24 CF 659. The state has already filed an information in that if the court would allow me to waive a formal reading, enter a not guilty plea on the 24 CF case. I would ask the court to leave both of these cases on the May 13th docket.
Okay. Ms. McBride, I'll see you on both of your cases on May 13th, okay?
I'll come see you at the jail.
Thank you, ma'am.
Joshua Land.
So I can print it out and give it to her before she leaves.
Yeah, I'll try.
Your Honor, this is Mr. Mann. He is on today's arraignment docket. There's 4 cases. Mr. Mann is going to enter denial for these 4 cases. He is in the drug court pipeline, so to speak. So we would ask the court to put this on, I guess, the May 16th docket, but I believe that hopefully will just be a status check. Hopefully he'll be in drug court by then.
Okay. So this is a VOP?
Yes, sir.
Okay. Mr. Mand, I'll see you back here on May 16th, unless you're accepted into drug court, and then you'll fall off my docket, and you'll be with the judge there. Okay. Thank you, sir.
Your Honor, this is Mr. Middleton. We did get the final restitution amount, and it is on this plea agreement. This time, Mr. Middleton
Awesome. Thank you.
is going to be entering a no contest plea. Let's copy that information for you. To 1 count of fraudulent use of a credit card. The agreed upon disposition is time served. There is restitution that was going to be awarded in this particular case, Your Honor. That is going to be $1,118.57 in restitution to Beverly Pohl, and the last name is spelled P-O-L. As part of this, Mr. Middleton is going to agree to pay also $3,563.04 restitution to Progressive Insurance Company, and that restitution is from Mr. Middleton's the cases that he's currently serving his DOs or his 1129 for whatever reason, the restitution was never assessed in those cases, and so the state had requested that Mr. Middleton agree to the restitution. So that $3,000 restitution is from his 2 previous cases. But the disposition here is time served. He would be assessed $615 in court costs, $150 in public defender fees. He's previously been adjudicated. I did discuss with Mr. Middleton how he wanted the court to handle the restitution amounts, and my understanding is he just wants the court to reduce those to a judgment.
Okay.
May I approach?
Yes, sir. Mr. Middleton, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you, sir. You can put your hand down. Mr. Middleton, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Middleton, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee, restitution in the amount of $1,118.57, and also $3,563.04. Those amounts will go to a civil lien or judgment.
Yes, sir, Your Honor.
Thank you, sir. Good luck to you.
Yes, sir. Thank you, and God bless. Good luck.
Thank you.
Yes, sir.
Mr. Williams is next. She's on both the 9 and the 1 back.
Thank you. Hello, Ms. Weatherford. Woodham. Okay, hello, Ms. Woodham.
Hey there.
Good morning.
Judge, this is Misty Woodhams before the court in a violation of probation in 2 cases, 23 CF 2255, 23 CF 2382. In preparing for today, I also saw that she was on the arraignment docket in 24 CF 605. She currently has no attorney listed in that case. I already represent Ms. Woodhams in the 2 violations of probation. I don't believe her financially has improved any since she's been in jail.
Ms. Woodhams, do you want the public defender to represent you in that new case? Is that a yes?
Yes.
Okay, I do appoint the public defender for that case.
May I have a moment, Judge?
Yes, sir. Thank you.
Judge, that is currently set for the May 13th docket. I don't know if there's been an information filed in 24
Madam
CF
Clerk says there's
605.
not.
Because there's been no information filed, can we set this over to next week on the 18th?
Yes, sir.
And put all of Ms. Woodham's cases together? I know that she wishes for me to move as quickly as possible towards a resolution here. So I'd like to try to do that for her.
Okay.
Now that I'm appointed, I can. However, Madam Clerk wishes to put it on the docket, I'm happy with. That's fine. That's okay.
Okay.
You'll be back in court on next week on the.
So I'll see you a week from today, okay? Thank you. Okay. Okay, yes.
Before we take a break.
Yes, sir.
I did want to address on Ms. Burkhalter, there was a failure to appear, and I know the jail will hold her until they get an answer on this. Is the state intending to press charges on the failure to appear?
No, Your Honor.
Madam Clerk, can you please make sure that's noted on the minute sheet? Thank you.
No, she's done, right? She's done for both. No, she's done for both. Ms. Wood. Yeah.
Okay, we'll take a 10-minute recess, and then we'll come back and finish up the morning. Thank you.
All rise, please.